Doesn't say that, does it?
Okay.
Alter, yeah. I can use AI. You know, at this point, I'll take my chances of litigation later on, arguing against a contract agent and driving up there and spreading schemes and not do something about it. I really can't.
There was some other, I don't know.
Do I want to? No. So, I guess I'll spend my time fighting some more equal fights. Yeah, really. Although it's not going to CRS, it's going to regions. Regions may be striking deals with some people who won't be told about.
Yeah, but
Especially at
Full service.
I love it. Thank you, Jay. They know what you did. The guy doesn't be right. So funny.
All right, folks, I think it's about 1:30, and I think it's time to get started. My name is Jerry Kang. I'm a professor here, and I'm really excited about the fact that this conference is happening, and the fact that we're at a moment where we can have a critical race theory conference panel that focuses on the question of the day, AI. And we have an interesting set of papers that will actually align, I think, in illuminating ways. My job is just to give very quick introductions. Each of the speakers will go on for 15 minutes, and as you can tell, like I like to, if you were here earlier, I like to ask hard questions, and so we'll just have an interesting conversation, hopefully, and then we'll have opportunity for the entire group here to engage in the conversation collectively. So the first speaker will be Chris Chambers Goodman. Chris taught here at UCLA, and I remember, like, we were kids once, and I remember when Chris was teaching back in the day here at UCLA. She's a professor of law at Pepperdine Caruso School of Law. She teaches many different things, including critical race theory. She's thinking about critical race theory, and has been producing a good number of papers actually on AI, which is really exciting, both the speed and productivity in that phase. So we're going to start with Chris. Number two will be John Taranian, who is a well-known IP scholar. He's the Paul Wildman Chair and Professor of Law at Southwestern. I know him from both the race work, actually, and the IP work. Footnotes, sometimes we have to do different kinds of things and sometimes merge them. I've lived that life historically as well. And then finally, we're going to have Moniz, who's a postdoctoral researcher in London intelligences, to finish it off, to also talk about perhaps colonial theories about the inputs which are so important in creating the data sets that actually feed and train up AI through machine learning. So 15 minutes for each person, and then hopefully a really interesting conversation afterwards, and just really an exciting time to think about these specific issues, and to make sure that people with racial justice on their mind are embedded in the earliest conversations, not after the fact as a bad kludge add-on to solve a problem that has spun out of control. With that, Chris, I invite you to the stage.
thank you. All right.
everyone. Thank you for being here. I'm super excited to just be with all of you people and our people, and so I'll just get started right away. And so, well, I guess I should. The title's a bit long. I was trying to shorten it, but I wanted to get everything in there. All right. So yes, you've been hearing a lot about generative AI, and so I wanted to just provide some background on how does that overlap, the biases that we see in machine learning, how does that overlap with a critical race theory lens, and then what do we need to do to transform these structures, right? These are parts of systems that are subjugating all of us in various ways, and some of us more than others. And so that's why I've been trying to do some research on this overlap. So first I'm going to talk about some of the foundations of structural racism in artificial intelligence technologies, and then I'll talk about sources of bias in machine learning data. And again, some of this, you may be familiar with, but I want to set that up as a background. I'll touch on, because I got 15 minutes, a little bit of some of the access to justice issues, some of the procedural due process issues, and other issues of, again, discrimination that operate in this space. And then I will wrap up with a few potential solutions and maybe a little bit about sort of what's going on in parts of the rest of the world. All right, so in terms of this, the basic idea about, can you guys see me if I go down here? Okay, so the basic idea of critical race theory and structural discrimination, structural racism, is kind of focused on this, right? This lack of intentionality. Well, with artificial intelligence technologies, people say, well, we're not designing them so that they don't recognize Black women's faces. That's not what we're doing. That's not our intent. But yet the impact is that they don't recognize my face as well, or someone with darker skin. This notion of banality, the thing, it's just, it's just a computer program. It's just gonna save us time. It's just gonna streamline our efforts, right? Well, yeah, it does that, but at the expense of what? Right, at the expense of individualized attention, and also at the expense of marginalized groups. Because artificial intelligence, for many people, because of automation bias, they think, oh, the algorithm is right. It's not biased, it's not unfair, but who created the algorithm, right? And what is the algorithm trained on? It's trained on data. It's trained by people. It's trained by humans. So we've got this structural biases built into this emerging technology, and one of the promises right now is that this structure is being created as we've had 25 years of CRT, right? Lots of structures were created before we even knew about critical race theories. And so there is a greater opportunity, I think, for some interruption of these biases. Now, of course, the irrelevance of the bad actor, right? That's something we talk about. And again, it's not any one person, it's not any one algorithm, it's not any one programmer that is causing the problem here. So some of the sources of bias in machine learning, I'm not going to read all these slides because there's a little too much words on them for me, but some of the sources of bias in machine learning are historical, right? Because history is what history is, you can't say that we've had female presidents in this country, because we haven't. So if you're just looking at the data and using the data of past presidents to help you determine, make a program about who should be the best president in the future, it's gonna come up a white man, right? Because we had one who wasn't, and he's an outlier. Outliers are disregarded, right? That's too far outside the data set. So we're not gonna worry about that. The other things that I worry about are the lack of diversity in AI education, in those who are learning to be programmers, those who are learning to develop the software and techniques. So I think that's part of a problem. In terms of the data quality, a lot of times we have inaccuracies in the data, and if we don't take the time to clean it up, to scrub it, then we're going to be, again, replicating more inequalities. So this chart is just to give you a sense of which demographics are getting education to compete in the AI space. And so we have technical teams. Those are the people who are like frontline going to be using AI. Technical team number 2 in the orange-ish, reddish orange, are those whose jobs won't be totally focused on AI, but they'll be dependent upon it and using it. And then the yellow is the total US workforce. So you can see the difference of white, Asian, and other races, Hispanic, Black, and Native American, Alaskan. And so these are the people that are in the pipeline right now. We've already talked about, so I'll just skip over this, the retreat, right? Away from DEI. Companies, corporations, organizations, and even tech companies are retreating from the DEI promises that were so crucial during the protests after the murder of George Floyd, right? That the things that really matter to us in the beginning of COVID and the middle of COVID, and for some of us even now, right? Those promises that were made. Well, the companies that are creating this technology, that are expanding this technology, are also backtracking on DEI. And so they are going to have a less diverse workforce, and so their programmers are going to be less diverse. And so many of the problems that we already see won't get better. They'll be exacerbated. In terms of gender, so these are people getting computer engineering, computer science, technology degrees. The green are, who's that? Men, yeah. The pink are women. Okay, so we see a big disparity there. There are some gender imbalances in these systems as well, and those we expect to continue also. These are just some numbers on who's getting PhDs, master's degrees in these fields, and the racial and ethnic breakdowns of them. And one thing to just point out is so many of our PhDs, more than half, are non-residents, people that don't live in the United States, are coming here for degrees in these fields. So that is something to think about. And so a couple of, I have 7 minutes left, is that right?
I have 8 minutes.
8, right on. Okay, then I can do it, because I don't want to talk as fast as Azza. Okay, so some of these things, issues to think about in terms of these structural barriers. I did some research in the use of artificial intelligence in the employment context. Lots of employers are using it, not just to screen through a bunch of resumes, but also to source candidates, to provide advertisements, to encourage certain people to apply. And again, to the extent that I'm not getting the targeted ad about a particular job that you're gonna get, right? We're also magnifying inequalities. In the hiring process, some employers are using video interviews that are conducted by chatbots, right? So maybe some of you have experienced that. And so there's this notion of interaction bias where some people don't interact well with chatbots, right? Sometimes you have a hard time getting them to answer your question. And if you raise your voice, it doesn't help, right? It doesn't help. And so what's going on with that interaction bias is some companies are retaining the data about how many prompts you had to respond to before you got it right with the chatbots. So that becomes a part of the evaluation. Well, if you're a totally tech-savvy digital native, maybe you interact perfectly well with chatbots. But interaction with a chatbot is not usually part of the job description. And yet it becomes a criteria for determining who is able to be accepted. Algorithmic redlining, I've got a few slides on that, but just the notion that some people are getting higher interest rates when they apply for loans, right? Some people are not able to get loans on their property. And then procedural due process, I could do a whole hour on that, so I won't, because Jerry will give me the hook. But with procedural due process, what we see is decisions that are made by government actors, government agencies, government offices, to the extent that those are relying upon artificial intelligence technologies to streamline the decision-making process, again, because of the scale, because of the volume, because of how quickly those decisions are made, we can end up with huge, huge disparities. And this was very pronounced during the COVID-19 crisis, when many people who had never before were applying for unemployment insurance benefits, right? some people lost their jobs, right? You don't have to raise your hand if you don't want to, but how many people moved during COVID or switched their workplace, right? Lots of people. Well, unfortunately, the algorithm was trained on pre-COVID data, and if you submitted an application for benefits from more than one address, it was flagged as fraudulent. And so they were just kicking people off by the hundreds and thousands because it was fraudulent. It wasn't fraudulent. They got sent home from college, or they worked from home or moved to Idaho, or whatever people did. So that is one of these examples that a human would notice that, but the way the technology was trained, it did not. Another thing was there was a man who was his benefits were reduced because he no longer had foot pain. He was a diabetic. Why didn't he have foot pain?
No foot.
No foot. His foot had been amputated, but AI said he doesn't need these benefits anymore because he doesn't have foot pain. The algorithm, the way it was designed, the decision that came out. Okay, so I talked a little bit about the bias in hiring, and so one other thing that I want to just highlight on hiring biases is when you are rejected from that job that you've applied to and you've interviewed with AI, they're going to retain that data too. So next time you apply, they know you've been rejected, and if companies are using the same systems or have access to the same data, then it becomes this like digital black box that you can't get out of. You can't get a job because you couldn't get a job. Okay, so that's just another point that again impacts many of us more. This was some of the things I already talked about: employment discrimination, mortgage bias, and also there's tenant screening algorithms, which again have a large impact on people of color. All right, the due process stuff I will move over. I've talked about public benefits. There's some slides on mortgage issues. And the civil justice system. One benefit of artificial intelligence technologies in the law is that it gives us a greater opportunity to help more people. If we have systems that are set up, to not replicate the discriminations that we see, it's going to help us to reach out and protect more individuals. So 50 million low-income Americans don't have adequate legal help. 85% of Californians with civil problems don't get legal help. All right, so these are, thank you. These are some of the things to be concerned about. All right, with evictions, we've got 96% of tenants facing eviction have no attorney. 70% of debt collection lawsuits end in default judgments, which are disproportionately against people from Black and Latino and majority Black neighborhoods and income levels. And then in federal civil cases, of course, we don't have a lot of litigants who are represented. There's a lot of procure going on. So we'd like to take advantage of the opportunities that artificial intelligence technologies can help with the law, but I want lawyers and everyone, law students and everyone to recognize that there is a downside to their use, and we want to make sure that we mitigate that. This is, you guys know this, legal aid funding crisis, so that gap in who gets represented is going to get larger and larger, and so we are getting to a crisis in terms of legal aid funding. And so these are just a few ideas of how to use AI as a tool for justice. One is diversifying the development, right? We want to look at what data is being used, how is it being collected, and making sure that groups are represented in the data. If people are not represented, well, then the algorithm is not going to work well for them. So how do we get more people to provide their data? On the other hand then, and this is another whole hour, there's the privacy concerns, right? Well, I don't want to give you my data because then you'll know more about me than I want you to know. But guess what? If Black women don't give their data, then it's going to be really bad for Black women whenever those algorithms are being used. So that's the issue. So we talk about the democratization of data, making data representative of all of everyone in the community. But then we also have to think about monetization of data, right? If you're gonna pay people from certain communities because their data is gold, right? Then that could be a way to encourage more underrepresented groups to, submit data. But again, once we deal with the privacy considerations. And so, okay. All right, so almost done. So a couple of other suggestions. When deploying artificial intelligence systems, maybe think about ethics first. Not can we do this faster, but should we be doing it faster? Can we cover these groups? Can we eliminate people from job categories with a stroke of a pen, stroke of a key? Should we, right? And so having those ethical questions answered before companies and organizations deploy artificial intelligence technologies would be one step. Another, and this is what some states are doing, and New York City was one of the first local areas to do it, was to require a bias audit. If an employer is going to be using artificial intelligence technologies to make an employment decision or to be a substantial factor in making an employment decision, then they need to have a bias audit done to see where are the discrepancies. Now, the New York regulation, of course, didn't actually say you had to do anything about it. You just had to have the audit. Okay, and then iterative adjustments. Keep retraining the algorithm. Keep moving forward and correcting its mistakes. Like children, sorry, all right, we're done. Thank you very much.
John, feel free to take the stage.
All right, well, thanks everyone for being here. It's a real delight for me to be at this conference celebrating the 25th anniversary. I want to spend a special thank you to all the founders and all the people that have worked with CRS and the program through the years. Thank you, Jerry, for founding it. I honestly think it's a really incredible achievement. I think over the years, I can personally attest the number of people that, for example, my law school has hired, the number of lawyers I've met in the community, and others who I've seen directly impacted by the critical race studies program here at UCLA. We've got a full generation of people, of alums under its wing, and they're going out making a difference in the world that I think is something that you just can't underestimate, and I felt the power of that. I had the pleasure of being a visiting professor here a couple of years ago. I taught constitutional law and entertainment law. And my students were asking such interesting questions through the course of the semester that I was teaching. And in part, it was informed by the theoretical constructs and the training they get through the critical race program. And that was very, very notable to me. And so thank you. And then in terms of my talk today, my talk is based on my forthcoming, actually I just came out book, The Secret Life of Copyright, Intellectual Property Inequality in the Age of AI. Just came out with Cambridge University Press a couple months ago. And I'm talking about a particular chapter in the book, which deals with this concept of capture. Copyright law's authorship doctrine, the body politic, and the politics of the body. And, sorry, let me get that going. All right. Like Jerry, who has operated, and one of the few other people who operates kind of in this dual space of critical race theory as well as intellectual property, for many years I've thought about how I might be able to fuse my two interests in this area. A few years ago, I wrote a book called Whitewash that was about the social and legal construction of whiteness as it applied to Middle Eastern Americans. A book which actually was recently withdrawn and taken away or banned by the Naval Academy. So I feel like it's thank you. I was more excited about the 200 other authors that were banned along with me. I was like, wow, I get to be in their company. This is pretty cool. Got like friends texting me, oh, I saw your name in the New York Times in this list. I'm like, yeah, well, who would have thought? So I wrote that book. I wrote another book called Infringement Nation that kind of talked about intellectual property rights and kind of the digital age. And for this book, what I wanted to do is fuse my background in critical race theory with issues related in particular to copyright law. And the short of it is, the elevator pitch for the book is really that it's about copyright law meeting Black Lives Matter and Me Too. And the argument that I'm making, as I call it the chorus, this is "Don't Boris, get to the chorus," is a famous line from the founder of Motown Records, Berry Gordy. So I tried to, heed that credo. And basically, the chorus is our copyright regime as a social justice problem. Despite its purported neutrality, we have key doctrines vesting the scope and vesting of copyrights, including the authorship doctrine, derivative rights, fair use, and First Amendment immunity, that have systematically disadvantaged individuals from traditionally marginalized communities, and thereby exacerbated inequalities along the axes of race, gender, and socioeconomic status. By itself, this is problematic. But on top of that, what's happening is these very doctrines are actually also betraying the utilitarian function of copyright law, which is to promote progress in the arts. And my book, I think, is timely in the sense that it calls for a re-examination of some of these doctrines at a particularly important moment of time, which is when we're having to re-examine all of copyright law in light of the important issues that artificial intelligence, particularly generative artificial intelligence, has been bringing to the forefront. We've all seen the big lawsuits involving Anthropic and Midjourney being sued by authors claiming copyright infringement. And this is a moment where courts can begin to reevaluate some of these doctrines. And my call is to think about them both from an efficiency point of view and an egalitarian point of view in a way that makes for both a more robust copyright system on egalitarian and efficiency grounds. Okay, so that's the basic argument. My argument today really deals with copyright's authorship doctrine. Copyright law has defaulted over the last last 2 centuries to a construct where effectively we believe that the person who fixes a copyrighted work in a tangible medium is by default its owner. I call this the authorship as fixation doctrine. On the surface, this doctrine seems perfectly neutral and it makes sense. After all, how are you going to trace the rights to a photograph? Well, find the photographer. But my argument is it effectively reifies the white male gaze. And for this, I'm arguing on the basis of Laura Mulvey's famous article or book, Visual Pleasure in Narrative Cinema, where she introduced the term the male gaze, right? Or the masculine point of view that's replicated in patriarchal hierarchies of traditional societies. And she used it and applied and deployed this theory in the context of film theory. But my argument is by giving the fixer the copyright, the person behind the camera, we are ignoring all of the creative inputs of other people who may be involved in a work, including, and most foremost, the subject, the person whose body and whose representation of their body is now fixed and controlled in a tangible medium that only the photographer, the fixer, can continue to commercially exploit for time immemorial, or as long as copyright lasts, which increasingly is time immemorial, okay? And so effectively, what copyright law has done is taken the male gaze, or the white male gaze, and propertized it through the vehicle of copyright law to control the representation of female bodies and non-white bodies in a way that obviously implicates dignitary and humanitarian interests, but also fails to recognize the contributions of women and non-white people to creativity and the creation of copyrighted works. So authorship as fixation basically vests rights at the time of creation in the fixer. And as I just said, right, that problematic conflation of authorship and fixation functions to deny performers property interests in creative works, rests on a faulty premise, betrays copyright's role in recognizing and rewarding creativity, and denies authorial interest to a class of individual subjects who provide significant creative contributions within copyright's traditional subject matter, okay? And I use the terminology captured because I'm intentionally invoking kind of the metaphor that Susan Sontag once referred to in photography, where she talked about the camera as a phallus. This is a modern reference, of course, to linguistics of photography. What do we talk about when people are captured on film? We use loading the camera, aiming, and shooting, the metaphor of prey. And I'm arguing that effectively copyright law has done something similar. And when you're wondering about, okay, well, the fixer, that just seems neutral. The fixer could be a man, it could be a woman, it could be a black woman, it could be a white man. right? It doesn't seem race-based. It doesn't seem gender-based or socioeconomically based. Consider this billboard from the Guerrilla Girls, kind of a rogue, fun little art organization that points out some of the deep inequities in the art world. Do women have to be naked to get into the Met Museum? Less than 5% of artists in the modern art section are women, i.e. the fixer. But 85% of the nudes are women, the fixed, the subject. We see this dynamic replicated throughout society, particularly worse in the old days when access to capital was necessary to have a printing press or to own a motion picture studio where we have the expensive equipment to capture people on film. This then favored people with capital who were tended to be more white and more male. But we still see that dynamic in Hollywood, where today fewer than 15% of directors are women. But the subjects are at least half women, right? So you see a race-based and gender-based valence to the fixer versus the fixed, and that provokes this issue. Now I'm going to talk about two just key issues, two examples of where this has come to the fore in recent years to kind of illustrate the dynamics of this copyright as white male gaze. On the left here we have Renty Taylor. I purposely cropped the photo because the rest of it is pretty offensive. He's naked. Why? He's a slave in the 1850s in South Carolina on a plantation. A guy named Zealey comes and forces him to sit for a bunch of daguerreotypes, him and his daughter, Delia. These daguerreotypes then are taken to Harvard University, where they are used by Professor Louis Agassiz, a very famous professor and also a white supremacist, to prove the inherent superiority of white people. Harvard, to this day, claims a copyright in this image. It commercially licenses this image, despite the objections of the ancestors of Renty Taylor. In other words, Harvard is commercially, complicitly taking advantage of one of the spoils of slavery, the fact that they could forcibly defrock this man, take his image, and then exploit it for time in perpetuity because of copyright law. When a few years ago, Tamara Lanier, who was a woman who was a descendant, a direct descendant of Renty Taylor, filed a lawsuit against Harvard University after she begged and pled with them to stop using this photograph, she lost the lawsuit. Why did she lose? Court recognized it. Said there is deep injustice in this. But our law of copyright says the fixer owns the copyright. Even if it was in the commission of a crime against humanity, they own the copyright. And so to this day, by the way, just a few weeks ago, Harvard announced they might stop using this photo. So we'll see. But almost to this day, they've been exploiting this photograph. By the way, side note, how on earth is a copyrighted photograph from 1850 still under protection? Weirdly, Harvard has a plausible argument through a bunch of really weird machinations. For those of you copyright nerds, the basic short story is they claim the work was unpublished until after January 1st, 1978, which under an obscure provision of the Copyright Act gives it protection till 2047, meaning Harvard has achieved 200 years of protection in this work. Side note. Okay. On the right, we have Erin Andrews. What on earth does she have to do with copyright's white male gaze? Erin Andrews, who you might know if you're a football fan or a Dancing with the Stars fan, she's a host, right, of TV shows and also a sideline reporter for the NFL. A few years ago, she was at a Nashville Marriott. She checked in, and then a gentleman who happened to be a stalker checked in right after her. He asked the Marriott people, hey, what room is Erin Andrews in? And they told her. He said, give me the room next to her. So they said, sure, why not? So he went, got that room, drilled a peephole through the wall, put a camera through it, and recorded her naked in the bathroom and decided it'd be fun to put on the internet. This devastated Erin Andrews. It destroyed her life. She sued Marriott, won a verdict of $55 million. She sued Mr. Barrett, won a verdict, but he's judgment-proof. But she was unable to do anything about the video. Guess why? Guess who the copyright holder is? The fixer. The guy who was committing a crime of trespass by peeping on her. That is default black letter copyright law. And she could do nothing about it. For 2 years, she had to negotiate with her tormentor to effectuate a copyright transfer. She finally got it 2 years later, but for 2 years, the video spread like wildfire on the internet. To this day, it's still available. You can find it if you want. She knows the internet is forever. It's never going to come down. And in large part, her representation of her body was controlled by a fixer that was deployed and empowered by copyright law. Okay? How do we come to this really weird, strange situation? We can kind of blame this guy. I don't like to blame him for too much. He's a pretty cool guy. Oscar Wilde, right? This is a famous Cerrone case. Burrough-Giles v. Cerrone. A whole bunch of years ago, the Supreme Court had to decide, can photographs be copyrighted? Some people said, no, they're a fact of science. Other people said, well, no, there's creativity in photography. Other people said, well, no, it's run through a machine. How can a machine create copyright? By the way, this debate should sound familiar. AI. Can AI be copyrightable? Well, we've actually already dealt with this problem before. We actually, reluctantly, but certainly held photographs have enough human input through the machine that the output is protectable, which differs from the current case law, which is still being sorted through on the AI issue. But how did this issue affect authorship as fixation? Well, this case has traditionally been read as saying the photographer, Napoleon Cerrone, was the copyright holder. Okay? And the court reasoned he'd done creative work, blah, blah, blah. Okay? However, students of this case typically ignore one of the most critical aspects of the case, which is the case didn't actually decide Cerrone was the copyright holder. In a footnote, Oscar Wilde and Cerrone had agreed by contract that Cerrone would be deemed the copyright holder. But if you think about it, who created the creativity? Who provided creativity for this image? Was it Oscar Wilde or was it Cerrone? Or maybe a mix? There's a pretty good argument that Oscar Wilde, through his very distinct affectation, his personality, his drapery, the way he holds the book, his particular pose, was just as much of a creative input to this image as Napoleon Cerrone. Yet for the last 150 years, we've presumed, because of this case, which really didn't adjudicate this issue, that the fixer must be the copyright holder. Now, at the advent of the era of AI, we have a chance to re-examine this doctrine, to look at the issue and say, you know what? When AI spits out product that is based on subjects who have been ingested in the AI system, maybe they too, because of their creativity, because of their input, deserve a copyright as well. And in the process, we will not only make the copyright regime more fulsome in terms of recognizing and rewarding creative interests, but we will also begin to redress some of the inequality where historically copyright has embodied this fixation doctrine that has cut along gender and racial lines to disenfranchise people of color, women, and those who are socioeconomically disadvantaged. So, thank you.
Hello everyone, my name is Melemaikalani Moniz, and my paper is about creating a decolonial framework for artificial intelligence. I am housed right now at the University of Hawaii at Manoa, but I work for Abundant Intelligences, an indigenous-led research project where we conceptualize, design, develop, and deploy artificial intelligences from an indigenous knowledge perspective. So first and foremost, this is my agenda. I'm going to briefly speak about my positionality before introducing the topic and applying it to artificial intelligences before getting towards my decolonial framework. So this is an Alelo No'eau, or Native Hawaiian proverb, and I start here, and it is Ke momole nei no, ka mole o'i, the descendants of I hold fast. I start here because this is a way to first and foremost ground the conversation in a Hawaiian lens of perspective, but also because the term mole, from a Hawaiian perspective, means source, ancestral root, foundation, and cause. It's important that when we're conceptualizing artificial intelligences, conceptualizing the way in which it intersects with race, that we're looking at it from an ancestral lens. So, coming into this project, my first thought that I had was, is there a way that we could reimagine artificial intelligence from a Native Hawaiian perspective? I think there's a lot of discussion, especially within the academy, about how it is that we can decolonize artificial intelligence. First and foremost, everybody talks about finding a way to mitigate the lack of data pertaining to indigenous peoples and even the lack of data concerning our epistemologies. And so when I came into this project, I wasn't sure how comfortable I felt about discussing artificial intelligence and application to my own people, and if I would ever be able to ethically integrate artificial intelligence with Native Hawaiian traditional knowledge. So I began to do research, and I found that there is Native Hawaiian critical race theory. And first and foremost, Dr. Wright and Belutsky were the first to kind of propose this framework of Kanaka-Oiwi or Native Hawaiian critical race theory. And this is important because it sets the stage for the development of what has become Native Hawaiian critical race theory. And this evolves from Hawaiian critical consciousness plus critical race theory and tribal crit theory. And they were originally trying to understand, could we use critical race theory to talk about Native Hawaiian experiences in higher education? Here is a nice graphic. I appreciate them for putting this in their paper. But they look at these tenets of critical race theory and tribal crit, and then apply it to Native Hawaiian critical consciousness, Native Hawaiian culture, the different experiences that we have as Oiwi or Native Hawaiians that are different than other people of color. And then looking at how we can bring the two together to create a Kanaka-Oiwi Native Hawaiian critical race theory. And so building off of that, Dr. Reyes then decided to conceptualize it from the idea of indigenous critical pedagogies, where she looked at as a nation that's subjugated and occupied. It changes the way that we conceptualize tribal crit in application to Native Hawaiians. Because while tribal crit looks at colonization as an endemic part of society, Native Hawaiian critical race theory then adds this dimension of occupation as an occupied people. And then finally, Dr. Cristobal took both of those perspectives together to create what is now the working framework for Native Hawaiian critical race theory. This is important because not only does it identify that occupation and colonization are endemic to society in our lived experience, it also makes sure to ground the analysis in a Hawaiian epistemology framework. This helps to be able to understand the analytical lens that could be applicable to Native Hawaiians and help us to be able to walk through the ways in which our occupation and our perpetual subjugation could actually lead to our liberation. Now, getting to artificial intelligence. I'm briefly going to explain it through the idea of capability. First and foremost, we have narrow AI, then there's general AI, and then super intelligent AI. There is some debate, and there's a lot of people who are contesting these different definitions because there are different people who believe that things exist. For example, narrow AI is what we consider to be ChatGPT. Some people argue that ChatGPT could fall within the realm of general AI. However, it sounds like those people are more so on the fringes, right? So narrow AI is where I'm going to categorize narrow AI is where I categorize ChatGPT as artificial generative intelligence. General AI is then pertaining to having a computer who is able to think like a human, right? And then super AI is really what we see in the movies. And so a paper came out by Events and Intelligences by Professor Jason Edward Lewis and Dr. Fonga, where they're looking at the ways in which the hegemonic weight of intelligence and the way that we describe intelligence from a Western epistemology actually leads to the marginalization of other people of color. And first they looked at this definition of intelligence, where we're looking at it as just an agent or an individual person's ability. And this is important, right? From an indigenous knowledge perspective, the way in which we conceptualize self, we attain knowledge, and then the way that we exhibit it, right, is not from an individual perspective. It's from our relationships with community, with our environment, and all else around us within our spiritual universe. And then the second definition that they looked at is this idea of intelligence, where actually when they traced it back, it pertained to scientific racism, where preconceived notions of race actually informed their findings. And so in response to these epistemic limitations, they're proposing that we use indigenous knowledge systems as a way for mitigation. It's important, though, when we're talking about artificial intelligence, that we understand that data is a driving factor. We need data for machines to be able to make decisions. And so from a Native Hawaiian perspective, based on our cosmology and epistemology, this is how we should be conceptualizing Native Hawaiian data. In our Kumulipo, the cosmogonic genealogical chant of creation, it informs the interconnectedness that we have as a people existing since the beginning of time. And through this interconnectedness, we not only have a genealogical relationship to our land, but all within our spiritual universe. So our land, our water, the air below, all of it is in relation to us. Native Hawaiian health and well-being is always gonna be tied to the life of the land. And because of this, any and all data that is pertaining to any of this, right, is rightfully Native Hawaiian data. The risks often seem to outweigh the harm. However, in this particular case, this is a tremendous benefit that I'm learning quite a bit about. So Lauleo, right, is a language revitalization app that currently is being created by a man named Keone Mahelona. And he is working with Te Hiku Media in Aotearoa or in New Zealand to create this app where actually you have a golden repository of Native Hawaiian speakers, and these speakers, they hold the key to understanding Native Hawaiian knowledge from a Native Hawaiian perspective. This is important, right? Because of colonization, the position that we're in is people are now having to learn the language, as opposed to Mauna Leo speakers who are born into the language and grew up conceptualizing the world through a Native Hawaiian lens of perspective. And so he's able to have people learn to speak, you speak and record it, and then it's measured against Mauna Leo speakers in his golden repository. This helps not only from just a language revitalization perspective, but this is a way to normalize Native Hawaiian language in everyday life. What's also very beneficial to us is that as Native Hawaiians, we don't have sovereign land where we can go and park our servers, right? And this provides us the opportunity to house all of our data right now on sovereign land in Aotearoa, where Keone is working with the Maori people to steward this. Some of the harms, right? First and foremost, cognitive imperialism. That's a really big harm. But also looking at it through this lens of the neoliberal perspectives that shape the way that not only AI is developed and created and designed, but also the way in which it's deployed. And it's also important that we talk about the data extraction, misinformation. I think oftentimes there's this idea that we'll just give as much information as possible to combat all of these epistemic limitations, and then hopefully that will lead to our liberation. But this is something we've already dealt with before, and this is just a new wave of colonization. And so another way to conceptualize this is there a way for us to look at something like cognitive imperialism and think about having agency over our epistemologies, yet still having it be part of the process of creating artificial intelligence and using it? So looking at it also in application to Hawaii, and when I say Hawaii, right, innately everybody should be thinking Native Hawaiians. That's important because there's a very big difference between Native Hawaiians and people who are not Native Hawaiian in Hawaii. And in order to understand that our liberation, right, comes from having connections to our culture and to our actual land, it's really important that Native Hawaiians are centered on Native Hawaiian lands and in discussions about Hawaii. In Chip War by Professor Chris Miller, he talks about the ways in which the semiconductors are being created not only in Asia but in the US. This is really important to note that there is legislation from countries like the United States, China, Japan, Taiwan, and South Korea. This is really important because, does anybody know if there's any legislation in Oceania about chip war semiconductors? There's not, right? Right now, Australia is considering ways in which they could join the AI supply chain. And New Zealand is using the CHIPS Act in the United States in order to get funding for their projects. But why is it that there isn't an actual framework for any oceanic country? Obviously, the power dynamics at play here, right? Understanding through the lens of imperialism, US imperialism, Asian imperialism, historically and present day, that colors the power dynamic between all of these countries in Oceania, and it does makes you a little bit uncomfortable to think of what will happen, right, when semiconductors continue to take center stage. It's important then that when we're considering a decolonial framework for artificial intelligence, we're not only looking at it as just Hawaii, considering that we're oceanic peoples, especially because Hawaii has a lot more power than other people in Oceania, and especially including New Zealand and Australia. And to begin to decolonize, we have to be thinking about it from this idea of collective resistance. I think oftentimes from a Western lens of perspective, we're usually thinking about the individual as opposed to the collective. And so looking at a decolonial framework collectively, what we can all contribute, it's important to then realize we can't actually decolonize all of AI, but we could work toward it. And so I'm proposing that we work at decolonizing AI ecosystems. And AI ecosystems are what the people who are designing it, developing, creating it, and deploying, much like we are in abundant intelligences, as a way to start working towards an actual framework that will help decolonize artificial intelligence. And so I'm actually doing this in my day-to-day life. The Abundant Soils Project, where we're looking at the intersection between Native Hawaiian epistemology and Western soil science and using artificial intelligence to achieve environmental justice. Based on Native Hawaiian critical race theory, I've created these integral components of it, where I look at first having a Native Hawaiian cultural foundation. In order to be able to integrate, even ethically, Native Hawaiian knowledge systems with artificial intelligence, you have to actually know your culture first. I think there's often a premise that Native people just kind of know, but because of colonization, many people do not. So everybody needs to have the opportunity to not only just even knowing our actual cosmology, learn about the ways that you can conceptualize and think as a Native Hawaiian, because that really does change the way that you can understand what a Hawaiian perspective is for artificial intelligence. Then that leads to an understanding of oppression for racialized peoples. Initially, I had written just decolonizing, right? Like going on your decolonization journey. Personally and collectively, that's really important because you can't actually perceive the value of Native Hawaiian culture without first decolonizing. So for example, an incident came up where someone had mentioned, well, all Native Hawaiian traditional knowledge relating to soil has been lost to time, right? That's not true. But if you're actively in the process of decolonizing, you always have kind of a red flag that goes up where you're like, that doesn't seem right, right? And so you can go through the process of actually finding the real answer. And so that's really important that we're constantly pushing back. But not everyone in my group is Native Hawaiian. And because of that, I need to create the opportunity for those people, those individuals, to be part of the process. And so I've made it a little bit more general as understanding oppression for racialized peoples. And then coming into competency with Western soil science, I am not a soil scientist. Yeah, I have to be able to understand soil science on a level where I can then integrate it. And then of course soil repatriation, where they repatriate the actual soil where they derived all their data from. And then understanding data sovereignty for Native Hawaiians, and then creating AI modeling, but also being actively part of our community so it's engaged in reciprocity as opposed to extraction. In conclusion, it's really important that we start critically engaging in the way that we can decolonize artificial intelligence. While it may seem impossible and honestly very domineering to be in this modern day and age where artificial intelligence really is transforming the way that we're looking at ourselves and our society, this is a way that we can start trying to create more liberation for different peoples around the world. Thank you.
Can I ask the speakers to come on up, and then we'll just have a conversation? Yes. All right. So we actually have a good amount of time, which is unusual. So I'm going to then, of course, occupy some of that time. I'm going to try to ask some hard questions, and I'll ask each of you a question just to start off things. And then I'd love it to get a response, but also to have other panelists engage if you have different thoughts or if you want to create a contributing conversation. Let me start with Chris. So in some ways you did a great overview of the many anxieties that people who care about just basic fairness might have with the rise of AI. But in some sense, because we use AI to mean a lot of different things, I want to try to figure out, I want to try to lock in a little bit better what you think is distinctively new. What I mean by that is there are lots of things that are sometimes called automated decision systems, right? We use machines and algorithms all the time to make things a little bit faster. Efficiency calls for it in modern economies, including countless ones. So we've always used automated decision systems, right? Just anything that processes a form, anything that might give you a credit score. So like our current credit system, for example, that gives you a FICO score that influences whether you can rent an apartment or not, that seems kind of like an automated decision system. It's never meant to be perfect, but we use it. That existed independent of what we consider to be AI. Most people, when they think about AI, they think, ChatGPT. So there's something about generative AI. There's something about machine learning. It's not a deeply rule-based training. It's just because it's done a lot of pre-training based on the entire corpus of anything ever written, mostly in English, that actually generates a neural network model that seems to kind of have an internal representation of the world and kind of think in ways that we're kind of surprised by. So it's a long setup, but the question is, how much of everything that you were anxious of is just about automated decision systems, right, where essentially humans play a relatively minor role? And I'm going to say that that's happened for a really long time. From the time since we've used spreadsheets, cutoffs, scoring of any sort, we've used automated decision systems to actually influence our lives. And anytime we use automated decision systems, there's anxieties about fairness and whether you got it right or wrong. Absolutely. What's unique about AI in that problem space?
Yeah, so I think there's three things. Thank you, Jerry, for that question. First is the three V's, the volume, the velocity, and the variety of what can happen with generative AI technologies. So we're expanding the scale of any sort of decision making that's happening. It's going across multiple areas. And I think one thing that is different here is the fact that these newer technologies are so much better at making connections that humans don't even see. And so by pulling in these diverse connections, they may decide that people with even numbered zip codes are the best workers for your company, because it just so happens that every worker in your company who's been promoted has an even numbered zip code. That doesn't correlate at all, but yet that could be the basis for decisions. So that the volume, the velocity, and the variety, I think, is one thing. I think the other thing is the backlash that we've been having over the past decade or more in thinking about what is color blindness and what is the effect of color blindness. And because so many people, again, due to automation bias, which I talked briefly about, they feel like the AI is fair. They feel like these decisions are fair and accurate. And I don't think we had an understanding back when easier decision-making, these earlier versions of decision-making processes were coming about. And so that push on fairness, I think, that push against the notion that AI is definitely fair and it's more fair. And then I think the final thing is, again, going back to another backlash against anything that's benefiting people of color, right? And so when artificial intelligence technologies are continuing to keep people of color down in the many ways that I showed on the slides, I think that's another reason why things are a little bit different in this space if you put all three of those together.
Super interesting. And so I just want to, and I invite the panelists to also chime in if you have thoughts on this, but I just want to make sure, so in some ways it's a continuous problem of automated decision making, but then you see slightly of an inflection point because of the three V's that you identified. The problem's getting worse in part because of what it is that AI can enable. Do you feel any optimism about AI potentially making things better than they were? Or are you largely pessimistic because if past is prologue, we know how technologies will be leveraged. I mean, we know how the internet worked. We know how, again, social media worked. We know, notwithstanding all the heroic assumptions about how technology might set us free, we tend to replicate a certain kind of way. Are you at all, are you kind of a downer on AI? Or are you secretly excited, you just don't show it to people?
Yeah, well, I'm not a total downer on AI. I do have hope to the extent that people recognize its limitations. It's, you know, with great power comes great responsibility. Was Spider-Man, right? Yeah, I mean, and so it can be amazing, and it can really help in so many ways. So that's why I talked about the access to justice issue. But I also think in the education space, it can help a lot. If we had AI tutors for kids that could really help kids at lower performing schools do as well as their peers at expensive, you know, higher performing schools, then that would be great hope for the future. But I think part of it is we need to have a particular mindset with AI developers, trainers. We need lawyers and law students to participate in this training and development, in these conversations, so that we end up with something that can actually uplift the least among us, and then we could all be in a better place. So I say I do have hope, but I'm still skeptical.
Any other things that you want to jump in on, reactions?
I was just going to add, like, you know, it's not the AI, it's not the machine, it's the humans. It's how we choose to use it, right?
Yeah.
And I think that's the case with all new technologies, right? It's about the discourse surrounding its use and education and awareness about what uses it's put towards that's going to ultimately determine whether it's more harmful than good.
I think for me, this is not really about the present day, right? I'm thinking about the future and what will actually happen if we don't start combating all of these limitations now. And I think we can even kind of, to some extent, look at the trajectory of even something like super AI. I know recently there was a signed petition that came out from leading people in artificial intelligence, where they talked about super intelligence could even lead to human extinction. So something like that, where we are conceptualizing the way that the trajectory of AI will actually go and how that could apply to us later on down the line, is really important to start understanding how we should be acting now.
Thank you. Hey, so John, I have a few questions prompted from your talk. Maybe just two. One is kind of a smart-assy question. It would sound something like this. It would be, well, you're saying about copyright as it's currently configured has really privileged the male gaze, and not surprisingly, that leads to a lot of injustice across social categories, gender, race, and other kinds of stuff. But it is actually those copyright holders that are most freaking out that large AI companies are ingesting their data into the large language models. So you could just say, like, well, you know, you're now getting screwed, so why should I worry about copyright? Because copyright has always, in some sense, helped the male gaze, the fixer. Right now, they're all in a freaking panic because their content is being ingested, distilled, patterns are being recognized, and then therefore, under maybe a derivative works story, it is now something that's entirely different. They can't get paid out for it, suppose, right? That's still being debated in different ways. And you might say, like, well, that's justice. Like, you're diluting copyright by having these large AI models make all of your content largely irrelevant because they've ingested it, learned the patterns, and can spit out something that's actually more interesting. So isn't that just delicious? That's the smart-ass question. I guess the other question I have is that in some of the examples that you showed about the abusive nature of someone who's taking and appropriating content because they're the fixer, we do have other laws like invasion of privacy, we do have rights of publicity, we have other kinds of systems that are supposed to catch on the back end. You didn't really talk about those, and I'm just wondering if those provide any relief outside of the fact that copyright is limited in its own way.
Yeah, so on the first question, you know, there is a narrative where the just desserts are coming to the rights holders.
Chickens are coming up to roost.
But look at the Anthropic settlement. That's a pretty big payday.
Share with people.
So Anthropic settled recently after being sued by a group of authors in a class action, agreed to pay $1.5 billion to approximately 498,000 book publishers, right? And it's going to the copyright holders. And those payments are going to be made. I mean, it's the largest copyright settlement in US history. And it's I think a harbinger of what the ecosystem is going to look like. Those rights holders are going to get paid. They're going to get paid because if you look at the way that court's decision was decided on a very weird, I won't get too much into the intricacies because it's copyright nerddom, but the court kind of gave a split decision, and it was very weird legally speaking, but it was totally intentionally to force the parties to settle so they would compromise. I think about YouTube. I think about what happened with YouTube at 10 years ago. YouTube was a cesspool of infringement. Now no one sues YouTube anymore. Why? One simple answer. They actually won the lawsuit against Viacom. but they ended up paying Viacom and all the rights holders. In the end, they decided to create a content management system that splits revenue 55-45 with all the content holders in the world. And guess what? Although you hear complaints, you don't see litigation. The rights holders are getting paid. They're going to be getting paid in these new models. What's problematic is the people who have been systematically disenfranchised from the pre-digital world and aren't rights holders are also, without further intervention, going to be systematically and deeply problematically, withheld from participation, royalties, and revenues in the new digital world. So that dovetails into your second question, which is, what about the invasion of privacy? What about the right of publicity? Well, invasion of privacy did no good for Erin Andrews. She could sue Marriott, they had deep pockets, but against the guy that who actually tormented her, she had a default judgment, something that did nothing for her, except it was useful in forcing her to use that judgment as a way of forcing me to transfer of the copyright. But at the end of the day, per se, the invasion of privacy suit did nothing to vindicate her copyright interests. And the reality is, with the way copyright works, where only rights holders in a digital environment have the ability to send takedown notices, absent an infringement case where you vindicate your copyright interest, you aren't going to get materials removed online. And that can become devastating. It can become devastating in a traditional revenge porn dynamic.
Well, why not go after Section 230 then?
Well, you could go after Section 230, but I have concerns about going after Section 230 for all the First Amendment. Section 230 is the Communications Decency Act that basically immunizes internet service providers from facing tort liability, including defamation. It has effectively allowed for a certain measure of freedom on the internet, and it is significantly under threat right now, and has been threatened by the current administration to be, overturned, either judicially or through legislation. And as a result of that, I would have significant First Amendment concerns about that. So that's the reason. And the right of publicity is so limited, the damages are not nearly like they are in copyright law, and there is no DMCA provision, which is this mechanism that copyright law provides for takedown in the digital environment. You don't get that with trademarks, you don't get that with right of publicity or any other intellectual property right. Copyright stands alone for having this extrajudicial mechanism of enforcement, and I think there's a huge gap in the law as a result. One of the cases I didn't mention that I do talk about in the book and that I have in my slides is a case called Garcia v. Google, which is where an actress was actually forced to try to vindicate her copyright interests because she started getting death threats when her performance was overdubbed to become this hateful screed against Islam, and she had a fatwa issued against her. She ended up suing, claiming a copyright interest. The Ninth Circuit originally found for her, and then en banc, basically Silicon Valley and the Hollywood studios got together in a rare show of kind of force together and got the decision overturned en banc because of the theory like, oh my God, this is going to destroy copyright law because there'll be fractured interests. But from my point of view, copyright law traditionally has worried so much about, God forbid, we have fractured interests, we want efficiency, 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 that we've harmed actually rewarding creatives and egalitarian interests. And there are lots of models I would point to, like music, where there are tons of fractional interests, where we have a perfectly competent system of rewards. And also Hollywood has actually done a good job, but not through copyright law, through collective bargaining, where actors and actresses get the equivalent of a copyright in their performance. Not quite a copyright, but think of residuals. Residuals are a royalty payment on the exploitation of your image. It's effectively like a copyright where the law hasn't provided one, they've negotiated it through leverage and through the hard work of organizations like the Screen Actors Guild. That's the direction I think we need to go.
Awesome. Okay, last set of questions, and then we'll have plenty of time, I think, for folks to jump in. So, Melanie, I want to appreciate, part of it is that given the limited way that my brain works, I need to be a little bit concrete sometimes. So when you say we need to decolonize AI, I'm going to give you maybe some choices on what that could mean. So and by AI, I'm talking about like developing large language models, which might be say the next version of ChatGPT 6 or Anthropic 4.9 or 5, Claude 5.0. One thing might be that what you're trying to do is scrub or add to the data set. So these LLMs are created by just doing a lot of the pre-training. It just means that you just need a large corpus of data. It's mostly English written text, and so you've got all kinds of questions about like Arabic text, Korean text, other kinds of stuff, whether that's ever getting in. If you want to decolonize AI, not necessarily, and you might be just saying, no, decolonize how humans think about it or use AI, but I mean decolonizing AI itself. would you be in favor of scrubbing the training data set? Which means either going through the corpus of data and seeing what parts you disagree with and deleting things because from your perspective, that data should never gone into it, or adding stuff that you think is not being actually included in part because there might be language difficulties and other kinds of stuff, right? Or pictographic differences. So one part might be in building up the model, do you want to scrub the data set? That's one thing. Not mutually exclusive, a second approach might be after the fact that you want actually either, people would call it sometimes, human-based reinforcement learning. Let's just say that you train up the model, you ask it a question, it gives you an answer, you say, well, this answer for whatever reasons is thumbs up or thumbs down. And you basically have a bunch of people who are Native Hawaiians who will actually look at every answer. You ask a lot of questions based about Hawaii or about Native culture. And depending on whether you like the answer or not, it's thumbs up or thumbs down. And you want that feedback to be integrated back to the model before it's released into the wild. So there could be stuff that's done beforehand on the training data set where it becomes just a black box parameter kind of model and you don't really know what it did. It could be after the fact where humans give it reinforcement learning that will then actually change it. There might be still other ways to, quote, decolonize the data. You can actually put in other ways or decolonize the AI. I'm just trying to figure out if either one sings to you or if I completely misunderstood your call for decolonizing AI.
Okay, first and foremost, I do want to talk about this idea of scrubbing data because it is important. When we look at it through the lens of epistemic dominance, right? What ideas, what knowledge is actually going to win in like this free marketplace of ideas? And usually it's not going to be indigenous knowledge, right? And so it is important to me that we think about the knowledge that goes in the data that are training these models. And I do feel a little uncomfortable actually scrubbing data. But knowing that epistemic dominance could lead to more marginalization for indigenous peoples, it would be really important that we then look at the data that's going into it on the onset, right? If we can find ways to make sure that the data going in is not the data that we would need to be scrubbing, it could make it a little easier. And I think this goes hand in hand with the concept of the AI ecosystem. Because I don't think I'm gonna ever be able to fully decolonize AI. But in order to get to a space where we can start challenging that, is creating AI ecosystems where we have the capacity to look at the data that's going in and actually training models based on the data that we would like to put into it, designing it, conceptualizing even the way that artificial intelligence is deployed. That could then help us to create more equity to some extent within the creation of that AI ecosystem. And while I would love to believe that we could just find ways to truly make every single step of that process fully, totally equitable, I don't think that's technically possible, right? And so having people who are part of the process, who are also going on their own, decolonization or actively anti-racist journey, to then be able to question themselves and see if they're even able to create and conceptualize and deploy artificial intelligence based on a more equitable system that leads towards liberation.
Yeah, it's super interesting. Just to follow up on that, there is some reason to think that actually just having the AI model ingesting the pre-training on the order of 250 documents could actually permanently change the way it thinks about a particular niche subject. So if you believe this to be true, and so you could actually launch and write 250 Wikipedia documents about anything that you consider to be significant from your epistemic position, would you do so, and what would that content look like?
Would I do so?
Who would do so? You gotta get some people to do it. Otherwise, you can have people who have no standing who are going to do it, or the absence is gonna, the omission.
And so you're saying that if I go ahead and create like 250 pages, and the hope
on
is
Wikipedia,
and the hope is to permanently recreate or change something.
It's just that because it's going to scan Wikipedia, and there's no other person writing on that subject. 250 documents will change those weights in powerful ways. Suppose that's true. I think there's reason to think it might be true. Would you actually have your team write 250 documents on Wikipedia?
I think maybe the question is more so, is it worth it? Because And here's the thing, what's really difficult about talking about indigenous knowledge systems in artificial intelligence is that we are all coming from the belief that even if you know your culture, you're able to input it exactly the way it's supposed to be. And so, is it worth it? Because in that context, it could be that what's actually indigenous knowledge, or from my perspective, right, as a Native Hawaiian knowledge that's going into artificial intelligence or creating these 250 pages, it could be in one instance worth it, but in other instances it may not be. And so understanding what it's worth the endeavor or not, I think, would be really important.
All right.
I think, Jerry, you've hit on the AI arms battle, right? Which is, if you're not doing it, someone else probably is, and they may be adverse to your interests. So there, I mean, that's information wars.
My Wikipedia page is often edited.
Yeah.
So
Speak from personal experience.
Yes, you know what I'm talking about. So people have been really patient. Sorry for asking so many questions, but let's get people to add. So Pierre first.
Yeah, I'm sorry, I'm Kate
Please
Caldwell, I'm from the Center for Racial and Disability Justice. I actually just wanted to respond to your conversation you just had, because that's been done recently, though on the other end of the spectrum, where Elon Musk fed South African white nationalist data into Grok and totally messed up his AI. So
be careful what you ask for.
So you can be careful, yeah, exactly,
Or
exactly.
do you get what you want?
Or
I don't think he got
counter
what he
program
wanted.
it.
Yeah, that's what I mean, yeah.
Yeah.
Okay.
But anyway, my question is, I work with, one of my areas of expertise is working with disabled entrepreneurs, and we have a lot of issues around intellectual property concerns that it just really haven't been addressed legally, really. There's a lack of work in this area, and one of the things that really stuck out to me is some of the examples you were giving, although it's not specific to copyright per se, is the labor that comes from these feel-good projects that you see a lot of corporations putting out, where they utilize disabled knowledge and experience to create a material. For example, the Nike Fly sneaker that was created by somebody with cerebral palsy, so that he could easily put on a sneaker without needing outside assistance. Or, for example, autonomous vehicles where you can enter using a wheelchair and exit. And these things, of course, never make it to market, but the people who created this, the disabled people, have no ownership over their own intellectual property, but the companies themselves couldn't have created it without their participation. And there's just really hasn't been anything in these discussions, and it happens on smaller terms as well, with a lot of service providers basically selling the things that the people using their services create while they're there, basically saying that because we gave you the materials, we own this. And it puts disabled creators, disabled entrepreneurs and innovators in this very vulnerable situation.
So appropriation on disabled.
Exactly.
Sort of creativity.
Yeah, and I was just wondering if you had any thoughts on any of that, just because I'm just trying to think through these things and make connections, and there's such a lack of work in this area.
Yeah, I mean, I definitely have lots of thoughts, but it goes into real aspects of copyright doctrine and some of the inequities, and also fundamentally providing better legal access to copyright lawyers, to individuals who are engaged in these kinds of projects, because they're probably signing assignment agreements that are giving away their rights. They're in the terms and conditions when they click on. You're saying they're not in the terms and
They aren't
conditions?
signing anything.
Well, no.
You downloaded the app.
Yeah, they are. We're all signing things constantly, right? You download a piece of software that Nike gives you, and embedded in the terms and conditions when you install it, it says you hereby agree that all work you create here is going to be assigned to Nike.
I would bet you the large companies and corporations do, but disability service providers, there's no paper.
Yeah, for those there, if there isn't paper, there are all kinds of remedies. They should talk to a copyright lawyer. The reality is, it's hard to actually consider someone an employee, so that whatever's created is a work made for hire, and as a result, they're probably an independent contractor, which means absent an assignment that's in writing, that person who created it owns the copyright. And there are so many people who have crawled out of the woodwork later on when someone is exploiting their intellectual property that actually end up doing pretty well in court because of that. So it's a matter of getting good copyright counsel more than anything. So
Yeah.
people in that position, if they have a product that is commercially being exploited, they absolutely do have rights because of the default rule. They're the fixer, they're the creator, they own the copyright.
Okay, I saw a question in the back, yeah.
Hi, so this question's for Professor Goodman, and I wondered if you could talk a little bit about some of the other structural barriers that people face when they're trying to seek a remedy for the kinds of civil rights discrimination caused by AI that you discussed during your presentation. So me and Nakisa here worked at the EEOC until recently, and we're part of the chair's AI committee, and working on the amicus brief in Mobley versus Workday. So we're having cases finally come through the court system to adjudicate some of the barriers, like questions about standing and coverage of employer entities and things like that. But every AI discrimination case in all of these fields is going to involve so much data, like we just talked about with the 3Bs, that they're very expensive cases to bring. And also, I don't think a lot of courts would order the level of discovery that plaintiffs' lawyers would need in order to actually prove up their case. And once you received it, you would need an expert in order to analyze it. So like something like the New York law does provide an audit that you could look at, something that you could seek in discovery, but you would also need all of the actual like applications in a hiring case, for example. So I think there's just tons of structural barriers, and one thing I've been thinking about is whether something like an intervention in standing, like something like having tester standing in a program like the HUD tester program could find the instances where people are being discriminated against, but that's another thing that would cost a lot of money to hire the experts and to hire the people to do all the applications and compare their outcomes and things like that. So I just wonder if you have any ideas, because I think people who are actually like employment lawyers, we suspect that many people are being discriminated against, and maybe they even have some like information that might indicate that, but it's a hard case to bring, and the economics of it are not really there. So.
Yeah, and so, I mean, one important thing is in the employment field, at least we still have disparate impact as a possibility, which we don't have in other areas of discrimination. And so the structural barriers, some ways to, where some states are trying to overcome those barriers, is they're requiring like bias audit, like a whole trail, and some, there's some pending legislation in several states in the United States, since that AI moratorium didn't go through, where they are requiring a specific, really detailed information about whatever bias testing has been done. And so that information needs to be provided to certain state agencies. Some states are creating new agencies to oversee that. So there will be some material in those states if this legislation passes, and that might provide a document trail or something that would be useful, at least for some people, right, who may be discriminated against. The other structural barrier is trade secrets. Right, I don't have to tell you how my algorithm works, because that's my algorithm. It's proprietary, and my competitors can't know about it. And I think that's the biggest hurdle that I don't see a legal remedy for, unless trade secret protection, which I'm not an intellectual property scholar, unless there's some way to lessen that trade secret protection. And so that is, so that's one thing. And then in terms of tester standing, yeah, I mean, that's interesting, and I think, unfortunately, the hard part about the tester would be, how do you get the perfect tester that's going to have the attributes in a way that the technology, is going to discriminate against them? And I think that's part of because the AI technologies will see so many other avenues and so make so many other connections that I think it would be really hard to find individual people that could provide test cases for you, because you wouldn't necessarily know why they were selected or not selected. I think that's the larger concern. But yeah, so I think there's about 20 states that have pending legislation that would address some of these issues, and so we'll see what happens in the next few months.
Okay, so would the EEOC be comfortable flooding the zone with resume studies? What I mean by that is you can just manufacture a resume. You know that it's keying off of certain things, maybe either because it's trained up or there's a very specific rule. Just change and swap out Emily for Lakeisha as names, the same basic profile, and just flood the zone, because the number of resumes that are being automatically processed, obviously, because the scale is just increasing by AI. Like, is that something that the EEOC comfortably does, where you manufacture and actually?
I've left the EEOC, they're no longer doing anything.
Well, now, yeah. Imagine an EEOC.
No, that's exactly what I have in mind.
Yeah.
And I don't even think you would necessarily need testers. There's such high unemployment right now. If you went to like worker centers and you just monitor the application, that way we can build our own data set.
Yeah.
On this side, they have all the data on that side and understand what's happening with unemployed people. What kinds of AI tools are they actually being faced with? If someone's autistic, is it, a video thing where they have to look into the camera, for example? Like, we can discover these violations, but it's unclear whether we're allowed to do it and whether we can use the data, but I think we could. It's just that it would be expensive, extremely expensive.
And so the other thing, I'm remembering a study that was done where they used several different Gen AI platforms to create resumes. So they made up names, some ethnic sounding, some white sounding, some foreign sounding, some whatever, and asked the AI to create resumes. And for any name that sounded Asian and or male, it was a technology background. Any name that sounded like it was someone who was not white had a languages skills section background. Like, they didn't tell it to do that. They just said create resumes. They uploaded a bunch of real resumes, and this is what it came up with. So it just tells you that the structural limitations are really, really huge.
Hey, so more questions? Yes, there.
Me?
Yes.
Well, thank you all for your great presentations. They were all thought-provoking. So I'm an assistant professor at ASU in sociology, and I teach undergrads, and I'm seeing that they're using AI to write their papers, to come up with their presentations in class, to come up with questions, and they can't explain what ChatGPT is saying about anything, right? And so I try to, I've been doing the blue books for in-class writing exams to really help them think about critical thinking, right? And force them to do it. And so I'm wondering, like, when we're thinking about hiring and algorithms, if we don't have people who have critical thinking skills, or just like go back to some other algorithm or whatever system, like, what does that mean for the future? And what does, the use of AI or overuse of AI, over-reliance of AI mean to like our Earth with like the environmental impacts, especially when thinking about decolonizing AI, like, is that possible? So just, I guess, thinking about the future in terms of the workforce and also the environment, what are your thoughts?
Do you want me to start? Yeah, so I'm doing a project on K through 12 education and uses of artificial intelligence technologies there and sort of around the world, and how different countries are addressing that. But one of the things that is not as well addressed in the United States is the concept of digital literacy and what does it actually mean. And so the current president's recent executive order on AI in education really focuses on teaching people to be able to use AI so they can be good workers. But in other countries, the digital literacy includes a critical perspective. And we don't want you to just be a good worker who can use AI and make use of it. We want you to be creating AI. We want you to be creating better systems and those sorts of things. So I think if we had a greater focus on digital literacy at a young age, some countries are doing it at like 4th grade. The students are getting AI critical analysis skills to work on, and continuing that through their secondary school, primary and secondary school years. So I think that would be one thing that would be that could make a big difference. But that's not the way that our current system, our current administration is heading. And I think really what we have here is we've got the super tension between innovation. We want to encourage innovation, but we also want protection and guardrails. And the innovation part is the balance is going this way instead of this way. Whereas in the EU, they're much more about protection than innovation. Whether their protections are well-founded or will actually work, who knows? But that's the tension for me.
John, and then Millie.
Go ahead, Mel.
Any reactions?
So for me, what's important is that I think we need to begin to shift the way that we're looking at teaching. When I was a teaching fellow, one of the biggest issues I had was ChatGPT, especially when most of their grade could be coming from a paper that they're writing. And even me giving them an entire semester to write that paper, the frustration of when you're looking at it and they've clearly used ChatGPT and did it the night before, when we talk about it every single class period, is very frustrating. And I think for a long time that frustration prevented me from being able to start looking at different perspectives. And I think part of being human is the capacity to innovate and change and be flexible and adapt. And so is there a way that we can shift education so that we can be more accommodating with using AI as a tool as opposed to a replacement, but also to make sure that students are actually developing the skills that they need? And I do want to say, last thing is, there was a comment, because I did make a similar comment about critical thinking, right, to one of my supervisors, and they were telling me that it seems to be that people say that every couple of years. And so he was so kind about it, and he was like, people thought that 20 years ago, when you were still coming up, and I'm over here now looking at the next generation in a similar way. And so I wish that maybe people created more space for grace for me. And so my big thought is, how can I create grace for the next generations to understand what it is that they need and actually give it to them?
John, final thoughts?
Yeah, I mean, I think it's about not having absolute bright line rules about AI, but rather showing that AI can be useful in certain contexts and is totally inappropriate in other contexts, and explaining to students why that's the case, right? So that the rules make actual sense. I mean, part of the problem is we don't have rules, right? Institutions are still struggling with rulemaking. My own law school still doesn't have an AI policy. And so that's a real problem. But I think saying, okay, AI is actually really useful. In fact, you damn well better know it if you're going to go into legal practice or you're going to go into various different careers. And here's how we're going to use it. But here's where it's not appropriate as a substitute for critical thinking. And here are the reasons why. And then give them examples of all the idiotic things lawyers did when they relied on AI and submitted it to a court, or the idiotic things judges did when they decided to use AI and don't get as punished the same way as lawyers do. But I think convincing them, I think making that case, right, of, yeah, this is strategic, it's beneficial, it's a very useful tool, but like all tools, you want to use it at certain times and not use it at other times, and explaining why.
And I say, use it to write your bad first draft, and then give me what its output was, and then give me what you did to change it, right? And then, yeah.
Awesome. We just scratched the surface. This was an extraordinary conversation. Let's give a big round of applause. Thank you. Well done.
Thank you.
Sorry for asking.